5 seconds to go. Start. The only ground on which accused number 1 assails the order of summoning is that the court ought not to have entertained a private complaint under section 200 CRPC, especially from a person covered by section 199(2) of the code, without following the procedure prescribed in subsection 4 of section 199. Stop. Para. Accused number 5, who is appellant in the other appeal, assails the order of summoning on 3 grounds, namely, that the respondent number 1 ought to have followed the special procedure prescribed in section 199(4) of the Code of Criminal Procedure, as he happens to be a minister of a union territory, that the transcript of the tweets attributed to him were not accompanied by a valid certificate in terms of section 65B of the Indian Evidence Act, and that in any case the tweets made by him per se do not make out a case of defamation in terms of section 499 IPC, punishable under section 500 IPC. Stop. Para. Reliance is placed by the learned counsel for the appellants mainly on the decisions of this court in PC Joshi and another versus State of Uttar Pradesh, Subramanian Swamy versus Union of India, and KK Mishra versus State of Madhya Pradesh and another. Stop. The contention of the learned senior counsel for the appellants is that certain consequences are prescribed in section 237 of the code, if it is a case of malicious prosecution initiated under section 199(2) and that the attempt of respondent number 1 to bypass the special procedure prescribed in section 199(2) is with a view to escape the consequences of section 237 of the code. Stop. Para. Defending the summoning order passed by the additional chief metropolitan magistrate and the order of the High Court dismissing the challenge to the same, it is contended by Dr. A.M. Singhvi that what is prescribed by section 199(2) of the code is a special procedure, which does not exclude the general procedure prescribed under section 199(6), and that the right of a public servant, as an individual, to prosecute a person for defamation, is granted by section 199(6), to which the provisions of subsection 2 of section 199 have no application. Stop. Our attention is also drawn to the 41st report of the Law Commission of India, which led to section 198B of the Code of Criminal Procedure, 1898, undergoing sweeping changes in the Code of Criminal Procedure, 1973. Stop. Para. We have carefully considered the rival submissions. Stop. In order to understand the scope and ambit of the two different procedures prescribed in section 199 of the code, it may be necessary to have a look at the legislative history of these provisions. Stop. Unfortunately, there emerges two versions of this history, one from the amendments made to the Code of 1898 in the years 1943, 1955 and 1964 and the Code of 1973, and the other emerging from the 41st report of the Law Commission. Stop. We shall take note of both versions of history. Stop.